So welcome to this Quadrant Chambers webinar on the new Commercial Court Guide, What Litigators Need to Know. My name is Tom Macey-Dare, and with me are my colleagues Nicola Allsop, Chilaeva, Turlough Stone and John Kimbell QC. We're all commercial practitioners at Quadrant Chambers, and John also sits as a Deputy High Court Judge in the Commercial Court, so he'll be giving us some useful additional insights from the bench. Today's webinar is being recorded and will be going up on YouTube later. We have a Q&A function. If you have any questions you'd like us to consider, then please add them there. Don't use the chat function for that. We will deal with the Q&A session at the end of today's webinar, but feel free to post your questions at any time. As we're recording this session, if you would prefer your name not to be read out with your question, please post your question anonymously. And we will be sending round a follow-up article in the next couple of weeks. So the new 11th edition of the Commercial Court Guide was published just a few weeks ago on the 9th of February 2022. It's available online and there should be a link to it on your email invitation to this webinar. It's the first new edition for 5 years. The previous edition, the 10th, was published in 2017 to coincide with the introduction of the business and property courts, which, as many of you will know, is the new umbrella grouping of various specialist courts and lists of the High Court, including the Commercial Court. The status of the new guide is the same as before. It's still simply a guide which tells you how the court normally expects business to be conducted. It's not a complete code for litigation, and it doesn't override the civil procedure rules or any practice directions. The new edition is not a rewrite. The structure and the content have not changed hugely. So if you compare the new edition to the old one, you'll see that it's arranged in much the same way. The titles of the sections are mostly the same, and much of the text is unchanged. But the new edition does contain some important changes. Firstly, it reflects a number of significant developments in commercial court practice that have taken place in the 5 years since the last edition. Those include the introduction of the shorter trials and flexible trials schemes, which began in October 2018, the disclosure pilot, which came into effect in January 2019, the important new regime for trial witness statements in Practice Direction 57AC, which commenced in April of last year, and of course the effects of the COVID pandemic, which has accelerated the move towards remote hearings and paperless trials. The new guide also reveals some fairly fundamental shifts taking place in the way that litigation is conducted more generally in the commercial court. And I use that word fundamental in two senses. Firstly, the changes are designed to achieve some of the fundamental aims of the Wolf reforms that led to the introduction of the civil procedure rules nearly a quarter of a century ago, but which have not sufficiently been achieved thus far. Those fundamental aims are encapsulated in the overriding objective in Part 1 of the Civil Procedure Rules, which is dealing with cases justly and at proportionate cost. And that includes, among other things, saving expense, dealing with cases in ways which are proportionate to their value, their importance, and their complexity, ensuring that cases are dealt with expeditiously and fairly, and allotting to cases an appropriate share of the court's finite resources. Achieving those fundamental aims requires cases to be managed by the court in ways which are bespoke, flexible, and considered, not in a one-size-fits-all way and not in a box-ticking way. And the new changes in the guide seek to achieve those aims, or at least to achieve them better than before. The second reason why I use the word fundamental is that a number of the new changes mark what appears to be a return to the old ways of doing things, the sort of procedural purism. Not purism for its own sake, but because the judges of the commercial court think that that will make for better case management and will better serve the overriding objective. And this trend can be seen in a number of ways. For example, in relation to pleadings, otherwise known as statements of case. It's long been the official rule in the commercial court that statements of case should be as concise as possible, that they should plead facts, not evidence, and that they should only plead the factual allegations which are necessary to enable the other party to know the case it has to meet. Those rules have long been honoured in the breach, and pleadings often contain general introductions and general factual narrative, and they often include allegations which are only relevant for their prejudice value. That all leads to additional cost and delays. And the judges of the commercial court are very keen to stamp out those abuses and to return pleadings to their original pure purpose. So the new guide makes it clear that pleadings should only contain primary allegations and particulars of those allegations, and it contains an important new definition of primary allegations, which is only those factual allegations which are necessary to establish the cause of action, defence, or point of reply being advanced. Another area where we see this return to fundamentals is factual witness statements. Now, these have been around in the commercial court for a long time. They were originally conceived as a way to save time and costs at trial by avoiding the need for oral examination in chief. The witness would simply put his evidence in chief into writing in advance. And there were other benefits too, such as encouraging settlement, part of the cards on the table approach to litigation. But over the years, as we all know, witness statements have mutated into something quite different. They tend to be drafted by lawyers. They often use lawyers' words rather than the witness's own words. And importantly, they have become a way for the lawyers to narrate the documentary evidence. In short, they've become less about evidence and more about advocacy. And that has corrupted the whole purpose of witness statements. It's also made them excessively long, which in turn has led to more time being required for cross-examination at trial. Practice Direction 57AC, which I mentioned earlier, and which was introduced last year, seeks to restore witness statements to their prelapsarian state by making it clear that the purpose of trial witness statements is to set out in writing the evidence in chief that a witness of fact would give if they were allowed to give oral evidence at trial without having provided that statement. And by imposing rules to ensure that nothing extraneous goes in, and the new commercial court guide makes it clear that unless the court orders otherwise, witness statements must comply with Practice Direction 57. Perhaps the most important area where one sees a return to the old ways of doing things is in relation to the trial itself. And one of the advantages of witness statements which narrate the documents is that when the judge reads the witness statements before the trial, she gets to know about the important documents in the case. So if you can no longer use witness statements for that purpose, how do you get the judges to read the documents for the trial? That's something which has exercised the minds of the judges of the commercial court quite considerably. Simply giving the judge a reading list in advance of trial is obviously not sufficient, at least not in all but the most simple of cases. And you can't narrate the documents in an enlarged skeleton argument either, because the guide makes it clear that skeleton arguments are only supposed to focus on the law, on contentious matters of fact, and on how the party's case will be put at trial. And there's also an upper limit on trial skeleton arguments, normally 50 pages. So what about the old trick of using cross-examination as a vehicle for introducing documents? Again, the guide says that's not a helpful way of doing it. The solution which the guide goes for is the return of the long-form opening, oral opening, in which counsel comes along to court, takes the judge through the important documents in the case, and by those means introduces her to the significant facts and the points of contention that are likely to arise. But that innovation, or that return to the old ways, is part of a wider suite of changes introduced by the new guide concerning the planning and the conduct of trials in the commercial court. So with that introduction and with those general themes in mind, let me outline the programme for the remainder of today's webinar. Turlough Stone is going to begin by discussing changes which the guide makes to the court's approach to case management, and he'll be developing some of the themes which I've just been discussing. Next, Maya Chilaeva will address one of the topics which is high on the judge's agenda, that is promoting junior advocacy in the commercial court. And Maya is the ideal person to speak about that as she's one of our newest tenants at Quadrant Chambers. She will also deal with what the guide says about applications in the commercial court. Then we'll have Nicola Allsop dealing with the important topic of proof of foreign law. That's an area where the judges have long been concerned about the need for careful case management to avoid inefficiency and unnecessary costs. Then it's back to Maya for a few words about the ever contentious topic of arbitration claims. Then back again to Turlough, who'll speak about new guidance on disclosure and the operation of the disclosure pilot. And then we'll turn to John Kimbell, who will address the new developments in relation to trials. And that will include a closer look at the court's approach to factual witness statements, the very important new innovation of the agreed detailed narrative document, and skeleton arguments, oral openings, trial listing, and trial time estimates. Then finally, Nicola will talk briefly about negotiated dispute resolution, a phrase which you may not have heard before, although I'm sure you'll agree that it has a familiar ring. And then at the end, there will be the Q&A. So over to Turlough.
Thank you, Tom. As Tom has identified, there are several themes underpinning what appears at first sight to be a new approach, but is in many respects a return to a way of doing things that would have been familiar to our forebears. 4 themes in particular stand out: judicial activism in the management of cases, the more efficient use of judicial resources, or if one were being a bit more cynical, making judicial lives a little bit easier, what Tom has described as the return to purism and clarity in the presentation and management and determination of claims, and the move away from a one-size-fits-all approach to a more bespoke one. Each of these is exemplified in the changes to case management set out in the new guide. There are a lot of changes, many of them are quite small. I'm only going to deal with a few of them, and with a few of the more headline points. And what I'm about to say is not exhaustive. I'm afraid you are going to have to read the guide in detail to work out what has changed. As far as judicial activism is concerned, as an example of that activism and of the bespoke approach that will now be adopted, there will now be the implementation of a practice that starts in the Chancery Division, whereby the court, specifically the judge, will triage all claims of its own motion prior to the CCMC to consider whether it's suitable for transfer out to a circuit commercial court in London or otherwise. At that stage, the input of the parties is quite limited. If the judge takes the view that it is suitable for transfer out, the parties will be given the opportunity to put in a written submission to the contrary. But really, once the judge has made his or her mind up, that's probably the end of the matter. If it's not transferred out at that stage, the rules make clear that it may still be transferred out at the CCMC, and the parties are required to give active consideration to whether the circuit commercial court is appropriate and to address the court on that at the CCMC. As far as the efficient use of judicial resources is concerned, there are a raft of changes here. There's an updated, much fuller case management information sheet. There's a new checklist for applications for service out of jurisdiction. And that's rather sensible because these applications were taking up a lot of court time. Very often key components of the applications were missing and judges had to refer them back to the parties for clarification. Now there's a simple checklist that ensures that all the ducks are in a row. More crucially, there are new provisions as to time estimates for trial. This is something that we discuss a little bit further down the line, but at the CCMC, the time estimate will now be for a single block listing to be inclusive of all judicial pre-reading and to have regard to the trial timetable. And as far as the trial timetable is concerned, this should provide for reading time after oral openings and indeed at other stages of the trial where appropriate, and also take account of the time that will be required for the production of written closing submissions and for the judge to read them. So in other words, the trial timetable, and thus the time estimate, has to assume a degree of downtime. And that's something that John will speak about in due course when he talks about trials. As far as the return to purism is concerned, there's a new express obligation on the parties to do what we should always have been doing. And I suspect, as Tom has suggested, that it was more honoured in the breach than the observance, and that's to consider what is needed for a fair trial of the dispute. And to achieve that obligation, the court now enjoins the parties to produce an advice on the evidence at a very early stage of the proceedings, and that's set out in Rule C6.1. And it imposes an ongoing legal obligation on representatives to give careful consideration to how they will prove their client's case at trial, or how they will refute the other party's case at trial. That informs disclosure, and I'll be speaking about that a bit later. But also, as Tom has mentioned, it is expressly relevant to statements of case. There is the renewed requirement that only primary allegations should be pleaded. There's a prohibition on the pleading of evidence. There is a very strict prohibition on lengthy background narratives. And the guide, in fact, says these are neither required nor helpful. And that's justified because, as Mr. Andrew Baker has said extrajudicially, all you're doing if you plead background is setting up potentially a lot of irrelevant issues in the sense of matters to be determined at trial by the judge that distract from the true focus of the action. There is an increase, somewhat paradoxically, in the page limit of statements of case before permission to serve something longer is required. It goes up from the current 25 pages to 40 pages. But there's an express statement that pleadings should ideally be no longer than 25 pages. I think the increase in the limit is just to cut down on the number of applications that judges have to deal with. Shorter is better, is the way that it's been described extrajudicially. And the guide makes clear that just because a case is legally or factually complex or of high value, that doesn't warrant more than 25 pages or exceptionally more than 40 pages. Drawing the threads together, in my view, those key changes are sensible and welcome. They do give some real teeth to the concept of active judicial case management. And they do grapple with the problem, the tendency of commercial litigation in business and property courts to become unwieldy. There will be some front loading of costs, particularly in relation to the advice on evidence, but that's not all bad, in my opinion. It has the utility of forcing parties to confront the merits of their claims at a very early stage and to focus on what's really important in proving or refuting a case. And it might prevent them from embarking on cases that are really going nowhere, from being forced down the line after the expenditure of tens or hundreds of thousands of pounds in costs, being forced to discontinue or to negotiate an unfavourable settlement. I don't know whether the others have anything to add on case management. If not, then I shall hand over to Maya, who's going to speak about the key changes to the rules for applications and a subject that will be close to her heart, I suspect, namely a new emphasis on junior advocacy.
Thanks, Turlough. I appreciate that not everyone will find costs and disclosure hearings as thrilling as I do. So I'll keep this as succinct as possible. In the time that I have, I'll focus on the key messages from the commercial court on junior advocacy, and then mention 3 practical tips for those doing application hearings under the new regime. The overarching message on junior advocacy is that it's very keen to facilitate junior advocacy. And the reason for that is to address the concern that juniors at commercial sets may not find themselves in a position where they spend actually much time on their feet. And the examples where you might use a junior given in the guide are CMCs, where the disclosure review document or cost budgeting may be very attractive tasks for the leader to hand over to a junior, and costs hearings. So beyond those examples given in the guide, I think there are some aspects of witness handling at trial that may be a good place to use a junior. When I was a JA at the commercial court, there were occasions when someone said that a junior would question a particular witness, or when the judge was corresponding with someone about the trial timetable. I remember he would put an express comment at the bottom of the timetable saying he was really happy that the advocacy was shared within the team. Turning to the specifics, there are two key changes to mention. The first is that it's clearer that the leader doesn't have to attend the CMC. That's not to say that occasion is any less important. So whoever is there will be expected to have the authority to transact all the important CMC business, but that person could be the junior. Secondly, there is language of encouragement of junior advocacy in D 7.1, E 1.4, and J 13.3. So there's a firm foundation in the guide for juniors to take advocacy work in lead cases. And what I think is particularly interesting about the rules is that they're not prescriptive. I remember attending Mr. Justice Foxton's combat lecture on advocacy last year, where he said that he'd prefer it if all costs arguments before the commercial court and consequential arguments were argued by a junior in a lead case, but they're not making that the rule. I assume that's because the judges know that costs arguments are sometimes closest to a client's heart. So it's down to us and our teams to work out what works best and when. Is the new guidance a good idea? There are obviously a range of perspectives to consider. I'm standing on a very different rung of the legal profession, and my view is that advocacy is part science, part art, but also very, very much part craft. There are things you can be taught, but a huge amount you have to learn just by doing. And the new guidance will help juniors to actually do more advocacy. So I think juniors will be very happy about these changes. And a tip I was given that's often helpful is that it's often helpful if you're fishing for an opportunity to do advocacy, particularly within a trial, is to emphasize to your leader just how boring the point is or how technical the witness's evidence is. And that seems to have the desired result of resulting in the leader deciding that's a particularly good point for you to take. Tom, as a leader, how do you feel about your juniors doing advocacy? Is that helpful?
It's very helpful. From a leader's point of view, you have to bear in mind that litigation is a stressful business. And if you have a case where it justifies a junior, then it will tend to be a case where the leader is under quite a considerable amount of stress preparing for all the parts of the case that he's going to deal with. So it's very helpful, and it's in the interests of the clients, in my view, for matters which can be dealt with by a junior to be dealt with by a junior. And of course, in terms of the interests of the bar more widely, I think it's obviously very important that juniors get real experience of advocacy in commercial court cases. I think that there are some juniors who the first time they ever get up on their feet is when they're doing their first big trial, and that's really too late. They need to start working in a smaller way in the commercial court on maybe points which are less important in the grand scale of things, although obviously they're very important still to the clients.
Yeah, and I think from the perspective of the client, maybe this is something we pick up during the Q&A, but to the extent that there is a reluctance to allow juniors to do advocacy because of a concern about lack of experience, I'd say two things. First of all, we already work very closely as a team on big cases, and the juniors will have responsibility for discrete areas, as you say, and will have detailed knowledge of these. And the barrister who's leading will always make sure that everything we do and say makes sense. And that's one of the benefits of being part of a strong team. And secondly, I think there is a responsibility on the junior. I've gone out of my way to find opportunities to practice my advocacy. I've taken a deliberate decision to take on some small cases of my own without a leader, as well as working as a junior on the bigger cases. So doing advocacy in lead cases shouldn't be so daunting. And of course, leaders will help as needed and would only give juniors parts of the case they were confident the juniors could do. In the time that I've got left, I thought I'd run through 3 key points to keep in mind if you have an application hearing under the new regime. And all of these illustrate the themes you mentioned, Tom, at the outset. So proactive, bespoke, considered case management. The first is be aware of the new time estimates for different types of applications. There are 3 main changes and they all relate to disclosure hearings. I won't run through them now, but they're at F5.5. The second point is about the content of interlocutory witness statements, which has been mentioned already. And the point here is that parties should not be arguing interim applications in their witness statements. That's at F8.2. What you need is factual evidence, which may be evidence to supplement any documents you exhibit, which you intend to argue about the hearing. And this is an attempt by the court to avoid the situation where the parties argue the application twice over, as Mr. Justice Baker explained in the SCAT case last year, so in the witness statement, and then argued as part of the argument in the case. And that point is even more forceful when one recognises that one has 2 opportunities anyway, the written argument and the oral opportunity. So to put it in the witness statement really is overload. The third point is about the use of expert evidence in interlocutory applications. That's at F8.6. The guide now says that in heavy interlocutory applications that are likely to involve expert evidence, as a matter of best practice, unless it's the shortest and the narrowest of points, you should identify early on that the application is likely to involve expert evidence and find a way of bringing that to the court's attention so that it can be case managed. And this is to avoid the situation where you simply serve a load of evidence, which then gets responded to, not necessarily in kind, which then gets replied to again, with ships passing in the night, wasting time and adding unnecessary cost. And there is an express link here to expert evidence on foreign law, which Nicola is going to talk about shortly. But just before I hand over to Nicola, there are 2 small details which you don't want to trip up over. The first is be aware that the deadlines for application bundles and skeleton arguments have changed, whereas people may have gotten used to these being due by 1, they're now due by 12. That's at 12 p.m. That's at F6.4, F6.5 and J6.2. And if you have an urgent out of hours application, there is reinforcement that that's got to be vouched. So with that, I will pass on to Nicola.
Thank you, Maya. I'm going to talk about proof of foreign law and the changes made in the Commercial Court Guide as to how we go about proving foreign law. And the changes in this regard really exemplify some of the key themes that Tom has spoken about. And that's the need for a proactive, flexible and bespoke approach to litigation and the move away from this idea that one size fits all. The law has not changed. The content of foreign law is a matter of fact, which must be proved. But how it's to be proved is a matter of procedure and practice. And that in particular needs to be approached with fresh eyes. And that's what this new guide is trying to make us do. We're warned against using a sledgehammer to crack a nut. And I'm going to just identify 5 key changes or themes under the new guide in relation to expert evidence on foreign law. The first is that the guide emphasises that the court has flexibility in determining how content of foreign law is proved at trial. And that leads neatly into the second point, which is the old notion that foreign legal materials can only ever be brought before the court as part of formal expert evidence is outdated. So what's going to replace that formal expert evidence in some cases? The third point, there are several options, and 2 of perhaps the more novel options are expert evidence identifying simply the sources of foreign law and the sources of interpretation, with the trial advocates then making submissions based on those sources, or they're being identified at an early stage judicial notice or agreement as to the nature and importance of sources, followed again by trial advocates making submissions. And John, I know when I spoke to you last week about this, you thought that the key distinction in this regard, which is likely to influence the court's approach, was as to whether the foreign law was civil or came from a civil or a common law country. I think that's right, isn't it?
Yes, I mean, that's right. I mean, I think the problem has been that it's been assumed that whenever a foreign law has to be is an issue, then you have to get an expert. And I've heard lots of complaints from judges that they've had to sit for days hearing evidence on American law or Australian law, and they really don't feel that they think they can understand the cases and the statutes pretty well without having to listen to two sets of experts. But a completely different approach might be appropriate where you've got a completely foreign legal system where you've got no idea even of the basics, and it's effectively a non-common law system that you're dealing with. So I think in practical terms that'll be the main distinction.
Yeah, and so it's important for us to identify at an early stage whether or not the foreign law we're dealing with is common law or not. My fourth point, all of this means that there's a need for greater cooperation and analysis at an early stage. Now, that's a running theme through the new court guide and, in fact, the recent pilots that we've seen as to disclosure and so on. It does mean that there is front loading of costs, although the commercial court, I think, would rather we saw it as a valid investment. And it's a valid investment because it hopefully means that the litigation will run more efficiently and more smoothly and will save costs in the long run. And the fifth point, the guide expressly acknowledges that a party may be able to use a foreign law expert already retained in proceedings, which is quite useful because in circumstances where a party's already instructed a foreign lawyer, perhaps informally, to provide some advice, no longer has to go away necessarily and then identify a further independent expert, although that will depend on cooperation between the parties and agreement, perhaps. So my view overall, the changes are welcome, they're pragmatic, and they should hopefully save costs. There's a potential downside I can see, which is that if expert evidence has simply been adduced on the sources of foreign law and the interpretation of those sources, when one gets to trial, it's not far-fetched to think of a new point arising, and perhaps without the assistance of a foreign law expert in court, the parties might be a bit hampered as to how that new point is dealt with. I don't know if I'm being unduly pessimistic about that. Tom, do you think that that's a risk in practice?
I think it is a risk, and it's a risk which, if it comes to pass, has the ability to disrupt proceedings at a trial. I think that the way that the court would respond to that is to say that it underlines the importance of the parties really being very thorough in their analysis of what the legal issues are in relation to experts, foreign law, before trial, so that sort of risk is minimised.
Yeah, absolutely. And so that really emphasises the need for this preparation in advance of the CMC and a really proper dialogue, detailed dialogue with the court. So I'm now going to hand back to Maya, who's going to talk about arbitration appeals.
Thanks, Nicola. The new guidance on arbitration, I think, is important not only commercially, given arbitration provides about a quarter of the court's business year on year, but also because the Law Commission has recently announced a review of the Arbitration Act. So this might be an area where we see further change. The court has always been discerning before allowing a challenge to an arbitration to go forward. And the new guide overall is consistent with that approach. So for example, there's a reminder at 08.3 and 08.4 about the limited parameters of sections 67 and 68 of the Arbitration Act. And secondly, the summary dismissal process has been extended to section 67 appeals. That's at 08.6. And I can see that a lot of our viewers are experts in arbitration and therefore will know that section 67 appeals tend to be one of two types. The first is a dispute about the scope of an arbitration clause. This is normally a short point of construction not involving any evidence. And the second is where there's a valid arbitration agreement, or rather there's a dispute about whether there is a valid arbitration agreement, and this tends to be in the form of a rehearing where parties can adduce new evidence. So given those differences, some might say it's not appropriate to have a summary dismissal of all Section 67 appeals. I personally think that if you've got a strong case, because there wasn't, you say, an agreement to arbitrate at all, or the arbitrators did something that was way outside what they should have been doing, then you have nothing to fear from the court architecture that is designed to weed out cases that are not good at an early stage. And it's in order that the system can really concentrate judicial resource on the serious ones. And there may not be many serious ones when it comes down to it. And that may be a hallmark of the quality of the reputation that arbitration has won in this jurisdiction. Not a debate for today, but certainly an interesting question, I think. And certainly the readiness to reserve the court for the serious cases is consistent with the overall ambition of maintaining the reputation of arbitration. So not leaving it without a corrective mechanism, but making sure that mechanism doesn't start unraveling the whole idea of arbitration. If an appeal is knocked out summarily, then I think that should be taken as a sign that it wasn't suitable, but actually the door is not shut. If something was missed, then in those rare cases, you can pick it up again, because you have a right to apply to have the case heard under 8.7. A word of warning, though, that if you do appeal and the application is dismissed after a hearing, you could have a costs order against you on an indemnity basis. So it's not surprising, perhaps, to hear the commercial court say that most of the cases dismissed on paper, nobody tries to renew. What this means for practitioners is it reinforces that there is a real premium on expertise and advice. And this is about telling your client not just that case is arguable, but whether it's serious enough. And that only comes with experience. And secondly, it's another area where a lot depends on the skill of the advocate at the written stage. If the client has good advice, the next stage for the client who says, I want to proceed, is that the written argument has got to be excellent. There's no room for a let's put something in, see how it goes sort of approach. So this is a good example of the theme you mentioned, Tom, of the importance of the advocate's role in the case. But it's really upfront. It's about bringing the best points out and doing that quickly, which is hard. And this plays across, I think, to the senior junior advocacy theme as well. It's a paradigm example where if you have a leader and a junior instructed in the case, it makes sense for the junior to invest the time in distilling the relevant material, and for the leader to have the detachment that a judge will have, which will give them a vantage point that is different to the view of the person who has to master the detail. So then the case can be presented in the best way possible. I mentioned at the start the Law Commission's review of the interrelationship between the court and arbitration. I think we're unlikely to stray very far from where we are on the appeals test, but we'll have to wait and see. And so with that, I'll hand back to Turlough to talk about disclosure.
Thank you, Maya. I can deal with disclosure in very short order, as there's nothing really new here. What the court has done is to write into the guide both the terms of practice direction 51U and the jurisprudence that's been generated by that practice direction since 2019. The principal takeaway is the emphasis on cooperation between the parties and avoiding disclosure looming too large as an issue within proceedings, wasting court time, generating satellite litigation, and ratcheting up costs. The key points are as follows. There's an express emphasis on the need to limit disclosure to what is necessary to deal with a particular case justly. And to further that aim, the disclosure review document should be kept simple and concise. And in particular, the list of issues for disclosure should be much shorter than the list of issues for trial. There's a new court sanction for overly long and complex disclosure review documents. So this is something that the court will be policing quite carefully. The parties are also enjoined to give careful consideration in every case, whatever its financial value or general complexity, as to whether it may properly be treated as a less complex claim for the purposes of disclosure, so that it can be dealt with under appendices 5 to 7 of the practice direction. As I mentioned, the parties are obliged to cooperate, and this will be policed. They must not allow, this is an example given in the guide, they must not allow the settling of the disclosure review document to become contentious or time-consuming or expensive. The use of multiple disclosure models is discouraged, and this may be a good thing because the parties might be able to push for old-fashioned standard disclosure in the form of Model C without too much resistance from the court. But what the court doesn't want anymore is some issues being dealt with under Model B, some under C, some under D, some under E. That just introduces too many layers of complexity. And the proof of the extent to which the parties have complied with those obligations will be in the pudding. The court now expects to approve the disclosure review document in no more than 1 hour within a cost and case management conference. If longer is required, then there's going to have to be a separate hearing, and that will obviously involve significant additional costs. So there's nothing really new here. It's merely synthesizing and putting into concrete form what's already been happening in the last few years. But it is something the judges, speaking extrajudicially, feel very strongly about. And I think we can anticipate that they'll not be slow in wielding the weapon of cost sanctions if they think that parties are not complying with the spirit of the new approach. And I think at some point they will be looking to make an example of an errant party. On that note, I shall now hand over to John, who is going to speak about trials.
Yeah, thank you very much, Turlough. So I'm going to talk about trials, in particular witness statements, the new thing that we've got to get used to called the agreed detailed narrative, skeletons, openings, and general practicalities of trial management. So starting with witness statements, new guide actually says a lot less than the old guide did about witness statements. All the stuff about witness statements needing to be concise and not containing commentary on documents is all gone. But that's not because it no longer applies. Quite the opposite. It's gone because all the guide does say, and all it needs to say, is that witness statements should meet the requirements of PD 57 AEC and should be prepared in accordance with the appendix to Practice Direction 57 AEC. But what you as litigators really need to know about the new rules is that the judges in the business and property courts are applying the new regime with vigor. They are absolutely determined to avoid PD 57 AC being applied in form only. That's to say, with a new style introduction, a new style statement of truth and certificate of compliance, but in the middle, old style witness statements. That is something that they are not going to allow to happen. There were 4 recent cases on it. You'll have the details in the note that we're going to circulate after the seminar, but there are 2 in the TCC, Mansion Place and Blue Manchester, and 2 that I'll talk about in particular, Knoxell and Bamako Steel and Greencastle and Payne. But the main message from these 4 cases, 2 of them from last year and 2 of them from this year, the main message is that A, simply complying with the formalities required by the new practice direction is not sufficient. And secondly, that witness statements really will be closely scrutinized for compliance. And as you'll see from, if you look at the, for example, the Mansion Place decision, a decision of Justice O'Farrell in the TCC, literally paragraph by paragraph in painful detail of non-compliance. 2 points to highlight. Failure to comply with the practice direction can mean that your case is lost at trial. So it's not simply that if you manage somehow or other to get your witness statement accepted and not thrown out at an earlier stage, and all the way to being confirmed by the witness you've called. That's still not going to save you if you have not in fact complied, as the Knoxell case, which is a case of Mr. Justice Andrew Baker, shows. If you haven't complied in fact, and that emerges very clearly in cross-examination at the latest, then the trial judge may well say that evidence is so unreliable that it's really worthless. So you can lose your case at a trial if you haven't complied. The second point is, as exemplified by the Greencastle and Payne decision of Justice Fancourt. That's unfortunately unreported, but I can tell you it was from 13th of January this year. In that case, there was a lead witness statement, so old style witness statement, very long, from the claimant, and had the proper introduction saying that it had been complied with the practice direction, had all the certificates, but in the middle broke literally every rule in the book, and the whole thing was simply struck out. And the reason why it's not reported is that it didn't go any further because shortly thereafter the case settled. I suspect on rather unsatisfactory terms as far as the claimants are concerned. So that's really the main message with about witness statements. The judges really do mean it, so watch out for that. So now turning to the completely new kid on the block, the agreed detailed narrative. This is an entirely new beast. It's a creature that emerged from a proposal of the witness statement working group. But that was a proposal for a narrative document from each party to replace what you saw in many commercial court witness statements, namely the long lead narrative witness statement, setting out the history of the relationship between the parties, exhibiting loads of documents, commenting on, and then I sent an email to so-and-so, then I go receive another email back, and at this point I was thinking this and this. That whole narrative that used to be in typically in a lead witness statement, it should not be in witness statements now, and will be struck out if you do try and include it. So where should it go? That was one of the questions that was posed in the witness statement working group considerations. And one proposal that came up was to have a narrative document from each side, a bit like a memorandum in an international arbitration. Anyway, it didn't get anywhere. Was not accepted by the judges and wasn't accepted by the working party. So that's why you don't see it in PV 57AC. But it seems to have come back in a slightly modified form. And what the court, what the new guide, this is section J 6.5, says is that in every case, consideration ought to be given at the latest by the time of the PTR to the production of this agreed detailed narrative. So what is it? It is supposed to be a document which sets out in chronological order a set of agreed facts. And as I said, it's not required in every case, but my hunch is that it is going to be the feature of many cases, and certainly any case over any trial of over a week. And what's really unusual about this document is that, contrary to the usual rule about virtually every other document you need to submit to the commercial court, which has to be no longer than X pages long in font size 12, or as concise as possible. Very unusually, what the guide says now is that this document says the fuller this document is, the more helpful it will be to the court. So in other words, type away. The longer it is, the better. But then the guide does rather, somewhat in a questionable way, says that this should not be a substantial extra burden. In other words, make it as full as you possibly can, but it shouldn't really be a big burden. Well, I'm afraid it's going to be. And it's going to be an important document, and it's going to be a document that the judges care about, because of course, the more of the agreed facts that you can present as litigators to the court, the easier it is for the judge to write his or her judgment. And of course, that is an important consideration. And so that the agreed detailed narrative, what I predict will happen is that will find itself virtually word for word being cut and pasted into the narrative part of the judgment. And at the moment, I can tell you, judges spend a lot of time piecing together the bits that aren't really an issue from the witness statements and the documents, and that normally that takes a lot of time in producing judgments. So the idea is to short circuit all of that by forcing the parties to agree as long a document as possible. have to say it is rather unclear how this new document is supposed to interact with the chronology that's still supposed to be produced. I can imagine there might be a tendency to merge the chronology and the agreed detailed narrative in some cases. Well, let's see. How it's supposed to interact with skeleton arguments, on the other hand, is very clear. So moving on to skeleton arguments, what the guide says now is that the agreed detailed narrative comes first. So it will be ordered at a CMC or a pre-trial review to be produced between the parties first before skeletons are exchanged, and that skeletons must, and this is in the new guide, take what is in the agreed detailed narrative as read. In other words, the idea is to have skeletons being shorter and more focused on propositions of law, the disputed facts, and how the party is going to put its case at the trial on the disputed facts. So the suggestion is avoid, just as you've got to avoid long narrative witness statements, similarly the judges don't want to receive long narrative skeleton arguments either. They want short, focused. And I think it's part of the theme that Tom was talking about earlier. In some ways it's a return to how many judges think that skeleton arguments ought to have been right from the beginning, i.e. very, very short documents setting up bullet points. So you can think how to think of this new approach. I think of it now as a sort of sandwich, maybe a pastrami sandwich, a thin skeleton on top, thin witness statements below, and a lovely big chunky filling of agreed detailed narrative in the middle, because that's the stuff that the judge doesn't have to worry about because it's been agreed, and what the judge has to worry about is the thinned out, concise and precise bits that are still in argument, and that's what the skeleton should address and what the witness statement should address. So that's skeletons and agreed detailed narrative. All openings. These have been repurposed, and the guide says that the purpose, not just a purpose or even the main purpose, the purpose of an oral opening is to introduce the trial judge to the important documents and facts of the case. And the guide contains a specific warning, which is, and I think Tom mentioned this in his introduction, do not wait until cross-examination to try and show the judge the important documents. So I think there's a move away from the performance in cross-examination where you hold back your best documents, the ones which really show the witness is lying, for that dramatic effect of cross-examination. Well, Mr. So-and-so, there it is. What do you say now? That it appears, sadly, some people may think, sadly, that's no longer approved of. So in other words, you need to know before you stand up and open the case, and that applies both to the claimant and to any defendant, what the key documents are for your case, and show them to the judge in the opening. Other parties will say, it says in the guide, usually have an opportunity to make a short opening. That in itself hasn't changed, but what's different now is because the purpose of the opening is to show the documents to the judge that you really care about and you rely on, then you as a defendant have to be sure that, that you have your own personal list of important documents. You don't just rely on the claimant to show them to the judge. So that is all openings. In terms of trial listing, pre-reading and time estimates, some of this has been covered already by Turlough. To sum it up and to give you a picture, I think what we're moving towards is a sort of salami trial, or a sort of start, stop, start trial. And we're moving away from the traditional start on at 10:30 in the morning and you continue the trial until the end, pretty much continuously. And in fact, most litigators, or more in terms of lining up witnesses, the main anxiety seemed to be never to be without something to do. You know, the great fear was always at about 3:30 you've run out of witnesses and the judge would be very annoyed. That appears not to be the position any longer. And instead of that, we're going to have more, as I say, of a sort of start, stop, start. Now so that happens right from the beginning. Trials under the new guide begin on the day of pre-reading. Now this is going to create some difficulty because some judges require more pre-reading than others. There'll be some judges who may require no pre-reading at all, or they do the pre-reading at the weekend, and then they'll call you in at 10:30. So all that you'll know is the trial is listed to begin at 10:30. You'll get a message from the judge, perhaps Thursday, Friday, saying no need to start until Tuesday, 1 day is required, or Wednesday, 2 days is required. But it's all going to be unclear, and it will depend on the individual judge. So it does mean that the litigation teams will be hanging around potentially for 2 or 3 days, costs being incurred, just in case the judge says, well, I've finished my reading, you can come in and we'll hear the first witness. We'll have to see how that works out. And in the new guide, we have even a 3-way salami slice on judicial reading. J 5.1 says we have to provide, or litigators need to provide a reading list which identifies separately the following: what the judge should read prior to opening statements, what, if anything, the judge should read after opening statements, and what, if anything, the judge should read at a later stage during the trial. So there's a 3-way potential slice. Your first tranche of pre-reading, then another tranche, and then another tranche. And for trials of more than 8 weeks, the guide says that consideration should be given to having opening in the previous term. In other words, you turn up, you open the case, and then say to the judge, right, now we suggest you go away and do some more reading. And the judge does that in the holiday before the new term. The judicial holiday, of course, that is, not the rest of us have to carry on working. Time estimates, therefore, have to allow for those potential stop and starts, and also for a time between the end of evidence and all closings. And it says specifically in J 10.1 that the judge must have time to read an outline of closing submissions before all submissions are made. And that pause, in reality, doesn't say this in the guide, but in reality, in most commercial court cases, that's at least a day to read the outline. I mean, we all know that the outline closing submissions tends to be quite a long document, especially if you've got your junior working on the document throughout the trial. So what does this mean? Altogether, it does seem to me to constitute a move away from the traditional continuous trial and towards much more a stop-start approach. What that will mean in practice, I suspect, I can't see any way around that time estimates overall will increase, and I'm afraid also I think that costs will increase. But there it is. So if that's put you off, Nicola is going to tell you all about negotiated dispute resolution. You can avoid a trial by simply settling the case under NDR. Nicola.
Yes, quite. So NDR, well, NDR is the new ADR. It is negotiated dispute resolution, and it reflects a desire on the part of the court to better integrate what was ADR into the bigger picture. So NDR is not to be seen as an alternative to litigation, and it's no longer to be seen as a discrete exercise that the parties embark upon perhaps after disclosure before witness statements. It happens maybe in a mediation for a day. If it doesn't result in settlement, everyone walks away, that's the end of it. No, we are now to approach it as something that coexists with the litigation. It exists alongside the litigation for the life of the litigation. And as Mrs. Justice Cockrell has said, it's not to be considered as an alternative because it is now a way of life, and that's how we must see it. So there's a new label, and there's some guidance in section G of the guide. But to be honest, the guide doesn't contain much by way of meat as to what's going to happen under this new label. And so, John, is it going to be just a label, or is it going to result in a fundamentally new approach? And if so, how? What's the judicial perspective?
Well, I'm afraid I haven't got a great answer on that one. Certainly, the idea is to try and concentrate the parties' minds, I think, at all stages of litigation on the possibility of settlement. Because until now, because we've used the word ADR, it's always been thought to be an alternative. It's something that we do in a particular phase, normally after disclosure and before people used to incur the massive expense of producing hugely long witness statements. That was the classic time to have a bit of ADR. And then you would stop doing ADR and you would get on with the real stuff of litigating. And so I think it's a serious attempt to try and say to parties, keep the possibility of dispute resolution, whether it's a mediation or settlement meeting or some sort of early neutral evaluation at the forefront of your minds at each stage. So I think we'll just hear that a lot more from the bench, both at CMCs, at PTRs, but virtually every time you come to court, the judges will probably say something about, well, have you considered the possibility of NDR?
Okay, so it's just going to be important for us as lawyers to bear it in mind at all stages of the litigation and be ready to deal with it at those hearings.
And not to take it personally. It's not a sort of, well, in this case, you might really want to consider it. It will be in every case that they will try. It's to divert cases away from the court and towards amicable settlement.
There we go. So I can see we've had some questions in. Thank you very much for those. I'm going to hand back to Tom, who's going to moderate the Q&A session.
Okay, so here's a fundamental question to start off with. How will the guide apply to cases which have already started in the commercial court, or will it only apply to new cases? Very important question to know the answer to. Any suggestions of what the answer is to that? Well, I believe that the new guide applies to all cases, whether or not they've been started. So there's no sort of parallel system of two guides running at the same time. Now, here's a question. What is the impact of the new guide on arbitration appeals? We've already heard from Maya about section 67 challenges. That's challenges in relation to the jurisdiction of the tribunal, substantive jurisdiction of the tribunal. Maya, perhaps you could say something about the effect of the new guide on section 69 appeals on questions of law.
Sure, Tom. I think there probably isn't going to be any change in relation to section 68 and 69 appeals. And as I covered in my section, whilst this might mean earlier dismissal of section 67 appeals at an earlier stage, really, if you have a strong case, whether it's under section 67, 68 or 69, then you have nothing to fear from the rules, because they're intended to weed out the weaker cases and to focus judicial resource on the stronger cases.
Okay, thank you. Here's a question from Jonathan Webb at Holman Fenwick. With regard to the agreed detailed narrative, is the devil not going to be in the agreed requirement? I can imagine endless and costly toing and froing over this. Maybe that's something for John to.
Yeah, I think, Jonathan, you're right about that. Speaking extrajudicially, Mr. Justice Andrew Baker has suggested a sort of rule of thumb, which is to go for the lowest common denominator. If you can't agree it, it doesn't go in. So there's going to be no forum, there's going to be no place in the timetable to come before the judge and plead your alternative narratives and say, well, the other side are being unreasonable, they won't agree to what we said about the contract on this or that basis. It's going to be simply left to the parties. If they can't agree, something doesn't go in. If that means you end up with a very thin, unhelpful narrative, then that may well raise issues at the trial, and the judge may say, I don't understand why you couldn't agree this on that, but at the most it will go to cost at the end of the day. I think what the judges want is what they always want, is the parties to cooperate in good faith to produce a document that will assist the resolution of the case. But we all know that there are cases where the parties are just such at odds with each other that it will be very difficult. But in those circumstances, it will just be a very thin document, I'm afraid.
Thank you very much, John. Now here's a question from John Habergan. This is a technical question. Is it the case that disclosure of a document is not on its own sufficient? To be adduced into evidence, a witness has to speak to it. Is that correct? Anyone like to deal with that? Turlough, you're looking thoughtful there. Do you have any thoughts on that?
It may well, in different divisions have different approaches. Here we're dealing with the commercial court, and the general practice, and John will correct me if I'm wrong, is that if it's disclosed, then that's probably sufficient. But the new approach, namely the introduction of the courts to the documents, it'll be interesting to see how it plays out. I couldn't answer that definitively, but I think what it's going to do is it's going to force the parties at a very early stage say what are the key documents here, and how do we what does the judge actually need to look at in order to make a determination. So it probably isn't going to have an actual impact on admissibility, but it is going to change the focus, and put the focus very much on, instead of 10,000 documents appearing in an electronic bundle, there's now going to be a much smaller number of documents to be looked at.
Thanks. John, do you want to add anything about that?
I was going to say that is right. The position is that the trial bundle, well, first of all, in terms of admissibility, if the document has been disclosed and hasn't been challenged, its authenticity has been challenged, it's accepted as effectively being a self-proving document. But the trial bundles are only supposed to contain those documents that you're going to refer the judge to and rely on. But it's certainly not the case that it's only those documents that are spoken to by a witness that are admissible. That would be totally at odds with the new practice direction. The witness should only deal with what he or she knows and is experienced with, from their own memory, and certainly shouldn't be speaking to documents in any sense. I mean, there is of course a difference if there is an allegation that a document has been fabricated, and that's different. But generally speaking, once the document is in the trial bundle, make sure if it's in the trial bundle, it's because you want to refer to it, and you will be referring the judge to it. Having done that, you can rely on it.
Okay, so here's an anonymous question. With skeletons being shorter and the agreed detailed narrative being the primary document, do you think that the first draft of the agreed detailed narrative should be prepared by counsel or by instructing solicitors? And your answer may reflect whether you think that barristers or solicitors are more argumentative than each other. Nicola, do you have a view about that?
I think it has to be a collaboration. I think there has to be a joint effort. And to some extent, it has to be approached on a case-by-case basis, because in some situations, the solicitors will have a better handle of the facts and the documents. In some situations, junior counsel, of course, might have a better handle of the documents and the facts, having done the disclosure exercise, perhaps. I think whoever drafts it first, I would definitely suggest that counsel is involved, because as I see it, what isn't going to go into the agreed narrative document is then going to have to go into the skeleton. And so it's going to be very important to make sure that that gap's not missed. And so if the other side say, no, that's not agreed, you need to make sure that you're keeping a running note. Well, okay, then that now has to go into my skeleton.
So does that mean that you regard this agreed detailed narrative document as more akin to a skeleton than a witness statement? It's more submission than evidence?
Yeah, I do. I think that's right. Although I suppose it's probably more akin to the old witness statement that should never have been a witness statement.
Okay.
Yeah, I think I agree with Nicola on that it has to be a team effort, because if it's going to be produced at all, it's going to be produced at some time in the run up to or just after the pre-trial reviews. You're only 8 to 12 weeks away from trial at that point. So it would be slightly odd to produce it without counsel, at least the junior being involved in its production. As Nicola says, if you leave something out, you've got to make sure it's in your skeleton instead.
Okay. So here's a question arising from what Maya was talking about earlier about junior advocacy. Is there a mismatch between the client's interests and those of the advocates when it comes to juniors doing the advocacy? For example, if a solicitor instructs an expensive silk anyway, isn't it in their interest for the more experienced silk to do all the advocacy? Does anyone want to? I know Maya's already been speaking a lot about this subject. Does anyone else want to jump in and give their views on that potential conflict?
I don't think the court the court has recognised, by virtue of the fact that it hasn't made the junior advocacy rules mandatory, that clients are entitled to instruct whoever they want. And so from that point of view, if a client wants to use a silk for a cost hearing or a disclosure hearing, that the client's perfectly entitled to. But I think perhaps sometimes clients don't recognise, and we have to help them recognise, that the junior is probably better placed to deal with some of these points because they have dealt with them in practice, they've done the prep, and the court is perhaps going to be more receptive to a junior making the submissions because that's what the guide is encouraging. And so the idea that perhaps a silk's going to do a better job might not apply in practice, is unlikely to apply in practice because the junior is better placed and the court is encouraging the junior to do the advocacy. And John, I think you've commented in the past that most judges really don't find the advocacy on costs, for example, as compelling as they might find advocacy on legal points. And so from that point of view, the court hasn't necessarily made up its mind, but might not be as swayed on submissions on costs as it might be on difficult points of law. Is that fair?
Well, I think it's more, as you said earlier, it's always helpful that the court really wants to hear from the person that knows most about the issue. Yeah. So if it happens to be the case that junior counsel, or indeed solicitor advocate, one of the other questions, to pick up one of the other questions in the chat box, is closer to the disclosure exercise and understands it, or is closer to the preparation of the cost budget, then that's the person the court wants to hear from, because that's the person that's got better access. And it's not going to be, the judge is really not going to be helped by the senior silk turning up, who clearly hasn't got a clue what's going on and is relying on, in the old days, notes being passed up, and these days probably WhatsApp messages pinging in every 5 seconds. It's all too obvious from the bench when that is going on. And you really just think as a judge, I'd rather just hear from the person direct. And that can be the solicitor advocate, the cost drafts person, or the junior. But as you said at the beginning, I think the important point is that this isn't mandatory. The client decides ultimately who they're going to instruct. And the judges aren't going to start saying, well, I don't want to hear from Mr. or Mrs. So-and-so QC on this. I want to hear from the junior. It's a gentle encouragement. But I think the conflicts can be resolved, as you say, by pointing out gently to the clients that in some respects, disclosure and costs being the obvious ones, it may be that the junior is better placed to assist the court.
I have just one other comment to add to that, if I may, which is that actually, as a client, you probably want the expensive silk working up on the next key witness whilst the juniors are dealing with the smaller points. You want them single-mindedly focused on the core case, and that's also what the rules now facilitate.
Yeah, and perhaps the other thing to say is that it's, if you're working together well as a team, solicitors, junior and leading counsel, it's not as if the leading counsel is not going to have a clue what's going on. You'll be talking about what's going on. You'll agreed the strategy. If there's any particular important point, on costs, or point of principle, or on disclosure, then you can review that decision and get leading counsel involved. You'll be working together as a team. And as long as that is in place, I don't really see that there's a serious conflict.
Okay, so excuse me. So we're coming to the end of the session now. I've just got one more question which I'll throw out there from an anonymous person on the Q&A. Is there a way to incorporate witness statements or sections of witness statements that were prepared before Practice Direction 57A came into effect into new compliant witness statements? And I think my short answer to that would be that it involves taking a red pen and crossing out very large amounts of what would be in the statement before the practice direction came into effect, and making sure that you simply chop out all of the material that is no longer permitted, until you're at a point where you can legitimately get someone to sign the declaration which is required by the practice direction. So it's a cutting rather than an adding function that you're going to have to focus on. So with that, thank you very much indeed, everybody, for the questions I hope we've provided some helpful answers. Sorry we couldn't deal with all of them. And once again, thank you very much, all of you, for your time today. And we will be circulating, as I said, a follow-up document along with a link to the YouTube recording of this webinar in the next couple of weeks. So on that note, goodbye.